Thank you very much to Michael and Fiona in particular for the invitation. We're very happy to be here, and it's good to see you all here today for this seminar. Now, when the UK signed the Aarhus Convention back in June 1998, a declaration was made confirming that the legal rights that parties are obliged to guarantee under the Convention are procedural, rights of access to information, public participation in decision-making, and access to justice in environmental matters. So even though the main body of the Convention does not contain a single limit value, pollution reduction target, or substance ban, it has, since its ratification, had a notable impact in the UK. We've seen developments that have influenced the way in which environmental law is both written and applied throughout the United Kingdom. The UK's approach to international law obligations is to ensure that the domestic legal system is compatible with international obligations before the treaty or convention is ratified. It is at this point that the international obligations bind the party. Following the adoption and transposition of EU legislation implementing the convention, and on the basis of procedural rights already provided under domestic law, the UK ratified the convention in 2005. There are a couple of features of the UK's system which distinguish it from many other parties to the convention, which are worth mentioning. One is the existence of three quite separate legal systems within the UK, England and Wales, Scotland and Northern Ireland, which is now, of course, reflected in the devolution settlement. And respect for those differences means that the implementation of the convention can look very different even within the territory of one party, which is perhaps a microcosm of the territory covered by the parties to the convention as a whole. The other key feature, which also of course applies in Ireland, is the common law tradition. This is founded on the basic principle that similar cases should be decided in a similar or common way, and the associated concepts of precedent and judge-made law. It is interesting to note that of the 46 parties to the convention, only 3, Ireland, the UK and Cyprus, have legal systems that are based on the common law system. Thank you. Thanks. It's also interesting to note that at present at least, none of the current compliance committee members are from common law parties. But before getting into a bit more detail about the convention's application and effect in the UK, it is worth noting this distinction from civil law systems because it can lead to different issues arising. I recently attended a seminar at which Joan Donoghue, who's a judge at the International Court of Justice, spoke about some of the challenges of dealing with different legal traditions in an international context. She mentioned that the different legal traditions were something more fundamental than just different rules. It's something broader and deeper. The way the law is taught, the ways in which weight is put on arguments, the way in which the legal profession is viewed. These can lead to international judges having very different reactions to the same issue before them, depending on their background and the legal tradition that they're used to. The Convention does not favour one legal system over another, and there is no suggestion that any legal system could not be compatible with the Convention. But to take one example of a different issue arising in common law countries, we could consider costs in judicial review claims. The costs of a common law adversarial system, where lawyers need to research a lot of case law and articulate the relevant principles for them to be weighed by a court, may be very different with a civil law tradition and an inquisitorial court system where the court plays a more active role in establishing the facts of a case and where the status of previous cases may not be as significant a feature. The same convention requirement for costs in relevant judicial procedures, not to be prohibitively expensive, applies, of course, to both systems. So moving on very briefly to look at how the convention has been implemented in the UK. The first thing to say is that, of course, given that the EU is a party to the convention, and that there is EU legislation implementing many of the requirements, there will be some similarities with Ireland. Taking the 3 pillars of the convention in turn, we have the Environmental Information Directive, which is transposed in the UK by 2 sets of regulations, one set for Scotland and one for the rest. These follow the directive very closely, but are complemented by the Freedom of Information Act, which applies more generally to information held by public authorities, so not just environmental information. Although the impact of the Convention needs to be seen against the background of a history of EU requirement on of environmental information, as we've already heard, the Convention provides another component to cases in this area. For example, on a question about the meaning of public authority and privatised utilities, the fish legal case was referred to the European Court of Justice, but had also been the subject of a communication to the Aarhus Compliance Committee. With regard to the public participation requirements, there are again obligations flowing from EU legislation, including the Environmental Impact Assessment Directive and the Industrial Emissions Directive. As these obligations relate to a wide range of environmental decisions covering both specific activities and plans and programmes, these requirements are reflected in various different bits of planning and environmental legislation across the UK. So rather than having a separate set of standalone public participation requirements, the Aarhus requirements are generally integrated into legislation dealing, for example, with environmental permits for waste sites or the review of nitrate vulnerable zones. This is also reflected in the planning regimes and legislation dealing with environmental impact assessments. I think this shows the integration of these principles in the various decision-making processes that are affected throughout the UK. Finally, there is the third pillar on access to justice. Now, beyond the access to justice provisions which are included in the first two pillars, there is no EU legislation on the more general Article 9.3 requirements on access to justice. The EU position is therefore that these requirements are left to the Member States to fulfil. There are some differences across the UK which reflect the different legal systems and the devolution of justice matters. But one recent development has been the codification of the practice of, which was originally developed by the courts, of protective cost orders being made in environmental cases within the scope of the Convention. Changes to the rules of procedure earlier this year for judicial review challenges put in place in England and Wales caps of £5,000 for individuals and £10,000 for others, limiting a claimant's exposure to the defending public authority's costs if they lose. A defending public authority is also has their liability limited under these new rules, but at a higher cap of £35,000, and it is open to the defending public authority to contest whether something is in fact an Aarhus Convention claim, which is what would bring it within scope. And we're beginning to see cases on the boundaries of the Convention in this context. Shortly after these rule changes were introduced, the European Court gave its judgment in the Edwards case. Now, this leads to a brief consideration of some of the leading UK cases in which the Aarhus Convention obligations are relevant. The Edwards case was a reference from the UK's Supreme Court. The case concerns costs and the meaning of the term prohibitively expensive, which is derived from the Convention. The European Court found that a purely objective approach was not actually necessary. The court, in awarding costs, must make sure that those costs are not objectively unreasonable, in order that the prospect of having to pay them are not a barrier to access to justice. However, the court may also take into account the situation of the parties concerned, whether the claimant has a reasonable prospect of success, the importance of what is at stake for the claimant and the protection of the environment, the complexity of the relevant law at issue and the procedure, the potentially frivolous nature of the claim, and the existence of national legal aid schemes or a cost protection regime. The costs are a big issue at the moment, and it is worth mentioning that we are still awaiting a judgment from the Supreme Court applying the criteria in the Edwards case, and that the Commission also has ongoing infraction proceedings against the UK on costs. Again, a judgment is awaited on that. There are a few domestic cases which are also worth mentioning. The Burkitt case was the first judicial reference to the Aarhus Convention, which was made by the Court of Appeal and reported in 2004, so a year before the UK had ratified the Convention. And we have seen more and more references to the Convention in respect of all three pillars since then, both in terms of the submissions that are made by parties bringing their cases before a court and in the court's judgments. I'll also briefly mention a couple of other cases which made reference specifically to the Compliance Committee, especially as we have Professor Giangiosco with us here today. In Walton and Scottish Ministers, the Supreme Court considered the Compliance Committee's views on public participation and said that their decisions deserve respect. The Court of Appeal in the Evans case, however, underlined the limits of this, stating that its views have no direct legal consequence. As to the communications that have concerned the UK, there's been quite a few of them, 27 that we're officially aware of to date, and I've put them together in this table. Quite a few of them have been found to be inadmissible because, for example, the communicant didn't provide the committee with enough information or because they'd not exhausted domestic remedies before taking their case to Geneva. The table really just gives a flavour of how some of the communications have developed. It's by no means captures every aspect of the outcomes, so it's really just a rough idea of how some of these have unfolded. For example, communications 45 and 60 are in the compliance column, but the committee also noted that some of the issues had been raised in an earlier case where there was a finding of non-compliance on costs, so the issues were not looked at by the committee again. And communication 68 is under the non-compliance column, even though most of the communicant's claims, which concerned a wind farm in Scotland, were dismissed by the committee. So just going through some of these cases by column, we can see the wide range of the subject matters that are involved. Communications 23, 27 and 33 all concerned access to justice and the costs of bringing challenges. These were respectively private nuisance actions regarding a waste site in Somerset, the costs of judicially reviewing a decision on the expansion of Belfast City Airport, and the granting of a permit for the disposal of waste material, dredge materials in the northeast of England. Following findings of non-compliance on the issue of prohibitive expense, the committee made recommendations in two of these cases, the first of them being a finding limited to the facts. On costs, the recommendations were for a review of the system for allocating costs in claims. And part of such a review took place in 2011 and 2012, with consultations across the UK on new caps for costs, as I've already mentioned, after these recommendations were adopted by the meeting of the parties in 2011 as Decision 49I of the parties. The Compliance Committee is due to report on progress at the next meeting of the parties next year in Maastricht, and we've been providing the committee with regular updates and met with them to discuss compliance with this decision earlier this year in Geneva. In the next column, there are a couple of findings of non-compliance which are still to be discussed at the next meeting of the parties in Maastricht. Communication 53 concerned access to information, public participation and access to justice around decisions on the construction of the Edinburgh tram system. The committee made a finding of non-compliance in respect of the release of data by Edinburgh City Council. It suggested that the release of the data prior to the committee's adoption of its findings then removed the non-compliance. And as mentioned, this will need to be further discussed at the MOP next year. The other communication, 68, concerned the installation of a wind farm and associated access road at Carrickgale in Scotland. Again, claims of non-compliance were made under all three pillars. The committee rejected most of the allegations about access to information and public participation in terms of taking due account of public concerns about the wind farm and the road, and the Scottish Government's plans and programmes on renewable energy. However, a finding was made regarding consultation on the high-level National Renewable Energy Action Plan. Cases where all new allegations of non-compliance were not accepted include Communication 38, so in the next column along. Here, a community group sought to allege breaches of the access to information pillar in connection with the proposed construction of a bypass around Aberdeen, as well as under the other two pillars. The committee rejected the allegations, but left the door open to consider the access to justice allegation following the communicant's use of a statutory appeal in 2011. Communications 45 and 60 concerned allegations about whether the planning laws of England and Wales met standards for public participation requirements. The committee found the communicants did not raise sufficient evidence to doubt their general compatibility, while on the specific examples provided, again, no breach was found in these cases. Communication 61 was an allegation that the hybrid bill legislative process used to enable the London Crossrail project did not comply with the public participation requirements. Although the UK maintained that as a legislative act rather than a decision of a public authority acting as part of the executive, its relevance to the Article 6 parts of public participation was doubtful, the committee found that the public was, in any case, adequately informed. Two communications were dealt with only by summary proceedings, where the committee considered that the same issues had already been raised before. These concerned access to justice issues dealt with by the committee in Communication 33 and rights of appeal under the planning system in Communications 45 and 60. One communication is on hold. This is the Fish legal case I mentioned earlier on the scope of the meaning of public authority, in which the committee is waiting for the judgment of the European Court on the issue. And for a country with many privatised utilities, this judgment is obviously of potentially very significant, and not just in the UK but elsewhere too. 4 more cases are ongoing, so I can't say too much about those at different stages. And again, there is real breadth in the range of issues that are covered. Just to give you an idea of those, it covers costs in challenging a nuclear national policy statement in 1977, access to environmental information, which was relevant to infraction proceedings under the Urban Wastewater Treatment Directive, and costs in private nuisance claims. Again, I think this shows the breadth of the subject matter and how widely these issues are being applied. Now, in the UK, DEFRA acts as the national focal point for the Aarhus Convention, so we coordinate all the responses to the Compliance Committee. But this slide gives some idea of how many different public authorities are called upon to feed into our response, and indeed how many are affected by communications made to the Compliance Committee. So we have local authorities, devolved administrations, other government departments, executive agencies covering a wide range of different topics and pillars of the Convention in the 6 years since the first case before the Compliance Committee. We've already heard a bit about the Compliance Committee, and we'll hear more later on this afternoon. It's fair to say that it is an unusual mechanism in terms of the way that it operates and the impact that it can have. Given the number of communications concerning the UK over the last few years, and as a party to the Convention with an interest in ensuring that the compliance mechanism works as efficiently as possible, we think it is helpful to provide the provide the Convention institutions with some observations on the process. I must just say, regarding the number of communications concerning the UK, the chair of the committee, Jonas Ebbesen, has mentioned on several occasions that a high number does not necessarily entail lots of problems with the party concerned. In the UK, as in Ireland, there is a strong tradition of NGO and individual activism, which is perhaps not the case in all other parties to the Convention. One point that we have sought to emphasise is the need for domestic remedies to be exhausted by a potential communicant before they take their case to the UN. We think that this ensures that the committee can see the full picture and check whether domestic processes are working properly. I think we have to accept that not every public authority can get every decision right every time, and I'm sure there's plenty of people here who can agree with that. But it is the review procedures that should be used to address any issues in the first instance. This would also prevent the committee from being overwhelmed and ensure consistency with customary international law. Indeed, the need to take account of domestic remedies and procedures is included in the committee's procedural rules. In June, just before the Convention's working group in Geneva, the EU had a short meeting with the chair of the Compliance Committee to open up a dialogue on this and on other issues. A meeting between UK government officials, the committee chair, and environmental NGOs followed in September in London. So, 8 years on, we can see the principles and processes of the Convention leaving their mark in the UK, and in the spirit of open dialogue and exchange under Aarhus, the UK engaging with NGOs and the Convention institutions. And we will certainly be watching events in Ireland over the next 7 years with a very close interest. Thank you.